Hello everyone. Welcome and thank you for joining us for today's webinar on immigration and COVID-19 challenges. I'm Jill McKerney, Head of Immigration in the Employment, Pensions, Immigration and Compliance, or EPIC team, and I'm joined by Pip Paig, who is an Immigration Associate in Team EPIC. This webinar is intended for Tier 2 and 4 sponsors. The focus will be on Tier 2 and much of it will apply similarly to Tier 4. This session is one of 12 webinars hosted by the Fieldfisher EPIC team. We will be hosting a 30-minute session every Tuesday at 1 p.m. covering various hot topics. If you have any questions about today's topic, please use the question box on your control panel on the right-hand side of your screen. We will then collate the questions and answer as many of them as we can at the end. If we don't manage to get to your question, we'll follow up with you afterwards. All of our sessions are available on our website and our YouTube channel. So the issues relating to COVID-19 and immigration are complex and rapidly changing. Today, we will address application procedure and timing for those applying to come to the UK and extending within the UK. The Home Office has brought in concessions to minimise the detriments applicants experience due to COVID-19, and we'll look at those. The common theme in the talk is that employers, universities and applicants will unfortunately be having to handle uncertainty and delays, which may mean that people are unable to start work or study when they had planned to. It may also involve an increase in administration. We'll try to help you navigate the issues as best we can by sharing the key points and some of what we're seeing in practice.
Hello everyone. My name's Pip and I'm going to be talking about timing, logistics and coming to the UK. So the key question is, can sponsors continue to hire from overseas? And the answer is yes. You can continue to hire from outside the UK. However, there's going to be delays. So what's causing these delays? First, the visa application centres have been closed both in the UK and abroad since the beginning of lockdown, with most applications being placed on hold. The Home Office has announced that they have begun a phased reopening of visa application centres in the UK and abroad. While some centres have reopened, in Sydney and Beijing, for example, many such as those in the US and India remain closed. This ultimately means that applicants can't secure timely appointments to submit the biometric information and in support of their application. The second of these is that there are currently no priority services available. Only the standard service of visa processing is available. So for Tier 2 entry clearance applications, the decision is usually made in 15 working days from the appointment. This means that standard applications can potentially take longer than normal due to backlogs. Excuse me. Is there anything else causing employers and sponsored workers difficulties during COVID-19? Well, there's a longevity of certificates of sponsorship, known as COS. Normally, a Tier 2 application must be submitted online within 3 months of the certificate of sponsorship being assigned. The Home Office has said that where a COS has expired, they will not automatically refuse the application and will consider those on a case-by-case basis whether to accept the COS. However, given there's an element of uncertainty with this, it's probably preferable to submit the application form online before the COS expires. Another thing to consider is the closure of English language test centres. The English language requirements still apply, and these haven't been waived. Approved English language test centres have been closed, but are starting to gradually reopen. The Home Office has confirmed that applicants can submit their application and attempt an appointment without an English language test, but their application will be placed on hold until they can take a test. So let's say the application has been granted and an entry clearance visa has been issued providing the 30-day window to enter the UK. But what if someone can't travel due to coronavirus? The Home Office has confirmed that those people can request a replacement vignette free of charge until the end of 2020. They must submit an online request. Once the visa centre reopens, they will be contacted to arrange for the vignette to be endorsed in their passport. Now let's say a sponsored worker has been issued a visa and has travelled to the UK. Is there anything else that they and their employer need to be thinking about? And the answer to that is yes. There's 3 factors. The first is UK's self-quarantine measures. These were introduced on June 2020 on the 8th, and they're going to be reviewed every 3 weeks. All new arrivals to the UK must complete a form on arrival with their contact details. New arrivals must arrange accommodation in the UK. Otherwise, the government will arrange this at their expense. New arrivals should not leave their accommodation for 14 days after arrival and should get food or medicine delivered. They can only go outside for urgent assistance or to buy food and medicine where this cannot be delivered. This is really important because a person can get fined up to £1,000 for failing to comply and may be contacted to check that they are complying. These measures apply to all new arrivals in the UK, with some exceptions, for example, those arriving from Ireland or in certain essential occupations. The second factor to consider are those unable to collect their biometric residence permits. For those, the Home Office has said that they will not penalise people who are unable to collect due to self-isolating or travel restrictions due to COVID-19. The third is dealing with a delayed start date. So a person, for example, applying on a Tier 2 General is not normally permitted to start work in the UK more than 28 days after the start date on the cards. So if you think this might become a necessity, we recommend that you contact us for advice. We're now going to look at all of these issues in the context of a case study. So Govind is a software developer. He lives in Bangalore, India, and he's got a new job in the UK. He's due to start on the 5th of June 2020. Govind cannot currently attend a biometrics appointment due to the visa application centre closure in India. His application should be submitted within 3 months of assigning his COS so that his COS doesn't expire. Once visa centres reopen, it's likely to take 3 to 4 weeks using standard processing route, probably longer for his application to be processed. If he can't take an English language test, his application will be placed on hold. He'll need to prepare for self-quarantining on arrival to the UK, and his sponsor should take advice if he'll be starting work more than 28 days after the start date on his COS. Now over to you, Jill.
Thanks, Pip. So can sponsors continue to hire from within the UK and maintain their existing workforce at the moment? Well, the answer is yes, but what factors do sponsors need to consider? They need to consider points around changing visa category, appointment availability, English language testing, and visa expiries. The Home Office has brought in a concession to allow those with visas expiring between 24th of January and 31st of July 2020 to apply from within the UK in a long-term visa category where they would normally need to return to their home country to apply. If your visa expires after the 31st of July, you can still make a request to apply from here, but this will not be automatic and it will only be granted at the Home Office's discretion. So if taking advantage of this concession, all other normal visa requirements apply, such as the resident labour market test and obtaining a restricted certificate of sponsorship. It's important to note that when applying in the UK, the online application must be submitted on or before the visa expiry date, even in COVID times. There is a COVID extension available, but this is intended only for those who are planning to return abroad soon, but are stuck in the UK because of COVID. People wanting to extend in the long term should apply as normal rather than using the COVID extension. So visa application appointments are slowly opening up in the UK, having been closed since the start of lockdown, but there are likely to be delays for some time yet. Currently, priority services are suspended and a Tier 2 decision is usually made within 8 weeks from the appointment date, and this timeframe could be longer at the moment. If a person cannot get hold of an English language test appointment, they can still submit their application online, but it will be placed on hold. And there are some English language test appointments now available in the UK. Another concession is that those applying in Tier 2 can start work in their Tier 2 role before a decision has been made in their application, as long as the Tier 2 online application has been submitted, the COS has been assigned, and they will be starting in the same role as listed on the COS. In this case, the sponsor's reporting responsibilities will start from the date the COS was assigned, not from the date of decision. Also, if for any reason the application is refused, the employment would need to be terminated immediately, so employers should proceed with caution. So we have a case study to illustrate these points. Victoria is Australian. She's a BD executive in the UK on a Tier 5 youth mobility visa, which expires on the 30th of July, and she's been offered a permanent role. Whereas normally Victoria would need to return to Australia to apply in Tier 2, she can now apply within the UK. She must submit the application online on or before the 30th of July. She cannot currently attend a biometrics appointment, but hopefully these will open up soon. If she and her employer agree, she can start work in the UK in the Tier 2 role before a decision has been made in her application, once her form has been submitted and her COS assigned, but her employment would need to be terminated if the application was refused. Her application will take up to 8 weeks and possibly longer, and she should get advice before making any plans to travel outside the UK. If she does not have a decision by the time of her visa expiry, her employer will need to carry out a fresh right to work check.
Thanks, Jill. So I'm going to look at some additional issues which will probably impact workforce continuity for sponsored workers. Some Tier 2 sponsored workers have been outside the UK during lockdown. Perhaps they've been working remotely. But what if you've got a sponsored worker outside of the UK and their visa expires? So we need to consider two things: the cooling off period and any potential discretion that it might apply. So the sponsored worker may be impacted by the cooling off period, and this will prevent them from applying for a new Tier 2 visa for 12 months unless an exemption applies. It is possible that the Home Office could use discretion to waive the cooling off period if there are exceptional circumstances. There would be a strong argument for this if unable to travel, and this will be decided on a case-by-case basis. The sponsored worker should try to return, if at all possible, prior to the visa expiry date to apply in the UK if they're eligible. Some sponsored workers may have spent 5 years in the UK and they're looking to apply for indefinite leave to remain, which is known as ILR. What if absences due to coronavirus breaks the continuous residence period and makes them ineligible to apply? So normally a person shouldn't have spent more than 180 days absence in any 12-month period before they apply. The Home Office's stance is that excess absences can only be waived in exceptional circumstances for ILR applications. The Home Office has indicated that it's likely that excess absences will be waived if they're stranded abroad due to COVID-19. So if this applies, the person should keep records, things like flight tickets, screenshots of any local or UK government guidance advising that only essential travel is permitted, and any correspondence regarding flight cancellations. These should be submitted in support of the application for ILR. As with English language discussed previously, are there any other supporting documents that could cause problems for ILR applicants? Well, at the moment, there are limited slots available for Life in the UK test. But if a person can't get hold of a slot, their ILR application will be placed on hold until they can take a test. And is there anything else? Well, priority services are currently suspended, and ILR applications can take up to 6 months to be decided on a standard basis. We're going to look at these issues again in the context of another case study. Mary's a research and development executive, and she has a Tier 2 general visa. She's been in lockdown in South Africa and unable to travel during that time, and she's been working remotely. She should try to come back to the UK before her visa expiry date, if possible. If not, she'd need to request that the Home Office grants discretion to waive the cooling off period. If she returns to apply for ILR, and if her absences exceed the 180 days, she should be able to request that this is waived due to exceptional circumstances and should provide proof of her inability to travel. She should submit her ILR application before her visa expiry date, and she can't travel after attending her biometric appointment or before her visa expiry date, whichever is earlier. At present, the standard processing time of up to 6 months will apply for her application. Over to you, Jill.
Thanks, Pip. So in the next few slides, we will look at concessions for sponsors in light of COVID-19. So firstly, what do sponsors need to consider around furloughing? As many of you will be aware, the government announced the Coronavirus Job Retention Scheme, or CJRS, on 20th of March this year. The last date for employers to place their employee on furlough for the first time was 10th of June. The Home Office has said that companies are permitted to claim funds from the CJRS in respect to their Tier 2 workers. However, Tier 2 workers must not claim benefits while on furlough. The company must comply with additional requirements when placing Tier 2 workers on furlough, and there are 4 of these, which are: firstly, the employer must not pay less than either 80% of the salary on the person's COS or £2,500 per month, whichever is lower, while the person is on furlough. Secondly, the reduction in salary must be part of a company-wide policy to avoid redundancies and in which all workers are treated the same. Thirdly, the reduction in pay must be temporary and pay must return to at least the level stated on the COS after the measures have ended. And finally, the reduction in pay must be reported on the sponsor management system within 10 working days. So we recommend that you keep records on file that these requirements have been met, such as letters sent to employees and board requirements. And we recommend that when notifying, you confirm in the notification that each of these requirements has been met. So one question we have been asked around furloughing is whether the person is a high earner and was therefore exempt from the advertising requirements. Can the company still furlough them even if it brings their salary below the high earner threshold? And the answer is yes, they can, as long as the above 4 requirements are met. Over to you, Pip.
Thanks. So some employers will want to know whether unpaid leave is permitted for sponsored Tier 2 workers. Normally, a sponsored worker cannot take unpaid leave of 4 weeks or more per calendar year. If this happens, this would usually require a report to the Home Office and possible withdrawal of sponsorship. The government has said that the company doesn't need to withdraw sponsorship and they don't need to report if the person has unpaid leave of 4 weeks or more due to coronavirus. The emphasis is on the reason being due to coronavirus. Examples of unpaid leave due to coronavirus are illness, self-isolation, and travel restrictions. Sponsors should review carefully in each case whether unpaid leave is due to coronavirus and take advice if they're not sure. They should keep a file note to explain this, and there's no need to report this type of absence as long as it's been authorised. If a company decides to reduce a Tier 2 worker's salary permanently, normally they can do so as long as it doesn't fall below the £30,000 minimum for experienced workers under the Tier 2 general route, or the minimum appropriate for their job role under the relevant SOC code. Otherwise, a permanent reduction below this level isn't permitted. If a company wants to reduce a Tier 2 worker's working hours and the person is in the shortage occupation, there's no indication whether they're permitted to reduce hours below 30 hours a week. It may be helpful here to quickly review the reporting requirements which currently differ due to COVID-19 changes. So on your screen, on the left-hand side, you can see there are a series of events. And on the right-hand side, it indicates whether a report is required. The first 4 are a change in start date, reduction in salary, reduction in hours, and redundancy or end of employment. For these 4 scenarios, yes, a report is required and it must be done within 10 working days. Where a person is absent on unpaid leave or their work address changes, including working from home, a report is not required if this change is temporary and due to COVID-19. All other reporting requirements remain in place.
Thanks, Pip. So our final topic today is how does a sponsor carry out a right to work check during the pandemic? So that's not a trick question. There are 3 ways a sponsor can carry out a right to work check. Firstly, there's the online right to work check. Currently, this is only available for those who either hold a biometric residence permit or who have status under the EU settlement scheme. The employee can register online to share a code with their employer, who can view the person's status online, and they would need to have a video call with the employee to verify their identity against the online photograph. This is likely to be the easiest option whenever it is available. The second option is where the employer views and checks the person's original documents, combined with either an in-person meeting or video call to verify their identity. Given that it may not be possible to view original documents in lockdown, The Home Office has said that employers can exceptionally carry out the check using a combination of a video call and by viewing scans of the documents. However, the concession may not be as helpful as it seems, because once the government has said that within 8 weeks of the COVID-19 measures ending, the employer has to carry out a second check by viewing the original documents. So this essentially means that they have to carry out 2 checks. They'll also need to use specific wording and would need to make sure they diarise that they will need to complete a second check. Thirdly, where a person has submitted a visa application before their expiry date, but a decision has not been made at the time of their expiry, the employer should use the employer checking service. Employers should wait 14 days following the submission of the visa application to allow for the application to show up on the Home Office's system. So the options are either an online check, secondly, viewing original documents, thirdly, relying on the scans and then completing a second check, or finally, the employer checking service. It's much less likely that the Home Office will audit during the lockdown periods, but sponsors must still keep records in the event of future audits. If sponsors have concerns about maintaining their sponsor duties, please feel free to get in touch with us. Over to you, Pip.
Thanks, Jill. So I understand we've covered quite a lot of content today, so we've put together a couple of takeaways. So what are these takeaways? The rules are complex and frequently changing, so please always seek up-to-date advice. Plan for delays and be aware of concessions. Maintain adequate records in case of future audits. Conduct timely reporting to the Home Office. It's not too early to start post-lockdown workforce planning. It's been confirmed that there'll be no extension to the transition period for the UK leaving the EU, and new immigration laws will be phased in from January. We have another webinar in July addressing some of these changes. So now we're going to take a look at some questions. Okay, so here we have one in. If someone needs to come to the UK urgently to work or join family, for example, what can they do?
Thanks, Pip. So the Home Office has said that if someone has an urgent need or compassionate circumstance, which means that they are unable to wait for the visa centres to reopen and the backlogs to clear to come to the UK, they can request a visa waiver by writing to the COVID team. They would need to give as much detail as possible of their circumstance so that these can be taken into consideration. So that this decision will be at the Home Office's discretion.
Okay, we have another question here. I'd like to know if there are any changes or concerns with intercompany transfer certificates of sponsorship. And I think this might relate to the fact that we've been referring to Tier 2 General here, Jill.
Yeah, absolutely. So thanks for that question. So there are some issues generally in terms of across the board in terms of obtaining an allocation of certificates of sponsorship. So most people will have requested allocations earlier on in the year, and there's usually a priority service available if these are not granted in time for making a visa application. So the main issue, I think, with the intercompany transfer cause may well be that there's still you may need to write to the Home Office if you have an urgent need for those to exceptionally request that they expedite your request for a certificate. Otherwise, the issues will be very similar as for Tier 2 General. So it will be the same issues around application timing, delays, and submitting your application within the 3 months validity period of the COS.
Okay, great. And we've got another question here. Can I start my course before my Tier 4 application has been approved?
Yeah, so there are very similar tier 4 concessions to the tier 2 concessions. So in a similar way that employers can allow their employees to start work once they've submitted an application, students can also start their course if it's agreed by their sponsor once their tier 4 application has been submitted and the CAS, or confirmation of acceptance for studies, assigned, as long as it's the same course as stated on the CAS. So they must not be studying with a legacy sponsor, and the ATAS certificate must have been issued. And of course, again, if the application is refused, then they would need to bring the studies immediately to an end.
Okay, great. And then we have another question saying, my visa expires in August and I need to apply for entry clearance. I'm currently in the UK. What should I do?
So if your visa expires in August, then you're in the unfortunate position where the concession doesn't apply to you, that you can switch automatically in the UK. So it also may depend on what visa category you're in. So there are some visa categories where you can automatically extend from within the UK, but assuming that you don't, so you need to apply for entry clearance, then you can, if there are if there are circumstances where you feel that you have an urgent need to, or you have a need to remain in the UK and not be disrupted, you can write to the Home Office to say, can they exceptionally allow you to apply for within the UK? Alternatively, it's possible that they will increase the 31st of July deadline, will extend it into August, depending on how things pan out. So you can also wait and see if that's the case, but unfortunately we may not know until later on in July. Otherwise, you also want to be considering the option that you won't be permitted to extend and you will have to leave the UK to apply, in which case you should also be preparing any documents needed to submit an application. It's also worth just keeping an eye on the visa centres, because lots of centres, as Pip has said, are opening outside the UK, and in some cases we've been able to obtain appointments fairly quickly. So it may be that your application won't be quite as delayed as you might worry. So it's just looking at all of those possible options.
Okay, great. And then we have one more question here. Do we need to be sending any comms round to our sponsored workers about what they should be thinking or doing in relation to COVID-19 and immigration?
Yeah, that's a really good question. So I think there's no harm, and I think it's always useful to send comms if you think that there are concerns around this area, to be reassuring to people that you are aware of their concerns and that they can come to you with questions, and then it's really for you to decide sort of what level of support you want to provide, whether you want to offer any legal assistance or point them in the direction of the government website guidance and so on. But I think it's for each company to decide. But I think if you do have people who are concerned about visas in your organisation, or lots of people who may be impacted, then it would be helpful to send around comms to send out a positive message that you're aware that there are difficulties and that you're available to support them.
Okay, I'm afraid that's all we've got time for today. If your question wasn't answered, we will be reaching out to you to answer it directly. Thank you everyone for joining today's session on immigration and COVID-19 challenges. We hope you found it useful. As mentioned, all our sessions are recorded and can be found on our website and YouTube channel. Thank you for tuning in. Please join us at 1 p.m. next Tuesday for Managing Pension Costs.